Good morning, everyone, and welcome to our webinar this morning on managing workplace disputes. This is the first in a two-part webinar that we're doing around disputes. My name's Allison Cook. I'm a partner in the employment team, and I'm joined today by Simon Martin, who is an HR consultant with Narrow Key HR and an experienced employment lawyer as well. If we could just move on to the next slide, Ellie. This is what we're going to be talking about today. We're going to be having a look at why workplace relationship management is important. And sometimes what comes out of that are grievances, and we're going to be looking at how to manage grievances, some of the tricky issues that come out of grievance that we deal with in this scenario. We're going to have a look at some grievance resolution, and then Simon's going to talk us through employee mediation. What I didn't say when I introduced Simon, which was probably one of the key issues that's relevant to today's presentation, is that in addition to being an experienced HR consultant, employment lawyer, Simon's also a qualified mediator as well. There is nothing that this man can't do. So Simon is going to be walking us all through how workplace mediation works in practice too. So if we could just move on to the next slide. So clearly how we manage relationships in the workplace is really, really important. It's how we all work together. It's how we produce the product that we are working for. It helps maintain a really good workplace culture. It likely feeds into an effective ESG agenda. Obviously, it helps you mitigate the risk of vicarious liability and discrimination. So ensuring that you as the employer, as far as you're able to, don't become liable for actions where employees go off on a frolic of their own. So really important that these relationships are managed, and also helps manage the wider risk of litigation, because if you don't deal with workplace issues, disagreements, grumbles around difference in treatment, then you could find yourself facing a whole world of pain should an individual be minded to bring a claim in the employment tribunal or indeed elsewhere. It's not on the slide, but obviously it's obvious, isn't it, that a harmonious workplace where everyone is happy, they're motivated, they're engaged in your core activities and objectives of your business, they're going to be more productive, they're going to be more efficient, more effective, and ultimately improve productivity, whatever your product is, whatever your productivity is going to be. If people are spending a lot of time feeling demotivated, feeling hard done by, dealing with disagreements as to how tasks are managed and so on, you're not going to have a terribly motivated workforce and productivity will drop down. So yes, managing liability is really, really important, but ultimately you are involved and interested in making sure that your workforce are productive. Right, let's move on to the next slide. So we've got here two boxes. So grievance versus mediation. Really, that's just boxes about what each process is. So a grievance procedure, for those of you who have experience of managing a grievance procedure, is where somebody can come forward formally, and we'll talk about the informal bit of it, to raise a complaint and have it dealt with. So I'm being treated badly because so-and-so said something to my line manager or whatever, or I'm not getting as much work as my colleague, and I think that's because I work part-time, or I'm not getting the career opportunities that I would like, and I think that's because of my part-time status, or it might be because of my protected characteristics. I mean, there are a whole number of infinite reasons why somebody might wish to bring a grievance, but that is some examples. So a grievance procedure is a formal process. It can, although complaints, grievances can be addressed informally by agreement. Shouldn't necessarily be adversarial, but can feel like it's adversarial, because you will be going to other people and saying, you know, this person has said this, what do you think about that? And we'll talk about some of the tricky issues that can flow out of a grievance procedure. It could be, couldn't it, that as a result of the grievance procedure, a disciplinary procedure may be triggered. And I suppose you have to question whether it's a long-term solution to the issues that are being discussed. Mediation, so that is a voluntary process that all parties have to agree to submit to. It's efficient. It can be done on a day. It's done. You end up with a mediation agreement where, if you get to that agreed outcome, and Simon will talk you through the tools and what you may end up with at the end of that process. It can be flexible, it's collaborative, everyone feels listened to, and it's solution focused. So that is some of the problems sometimes, isn't it, where you have a grievance procedure and people don't feel that they're being listened to. It's too adversarial, so you're not always going to get a good outcome. Okay, so that's sort of grievance versus mediation. Let's have a look at how you manage a grievance on the next slide. Just keeping an eye on the time. So what is a grievance? A grievance is any concern, problem, or complaint that employees raise with their employers. And you need to have a grievance procedure within your organisation to help you manage and navigate your way through a complaint. The ACAS Code of Practice on Grievances is a really good starting position, and that will show you what the minimum requirements of a grievance procedure looks like. If you don't follow a grievance procedure and a matter is ends up becoming litigated and it goes to an employment tribunal, for whatever reason, then the tribunal will consider the ACAS Code of Practice and will consider the extent to which you've complied with it. And if you haven't followed a grievance procedure, it's possible that the tribunal will make a compensation uplift of up to 25% for circumstances where you as an employer have unreasonably failed to follow it. So there are, excuse me, there are implications for not following a grievance procedure or a procedure that doesn't comply with the code of practice. So one step that you can take following this is looking at what your grievance procedure does. Does it comply with the code? Does it contain any additional requirements? Key aspects of the code are that matters should be resolved informally if possible. Fairness and transparency are key, a bit like a disciplinary procedure. It needs to be reasonably, it needs to be fair. It provides for a process to be followed, and you can think about using mediation. So just thinking then more generally about grievances, what are the common issues that that cause grievances to be lodged? Well, in our experience, it can be things like terms and conditions of employment. It can be people raising health and safety concerns, work relationships, I'll come back to that in a minute, bullying and harassment, new working practices, organisational change, discrimination. So I suppose probably just looking down that list there, work relations, I think bullying and harassment, organisational change, perhaps, and discrimination, they all sort of sit within that, don't they? In my experience, the majority of grievances that come over my desk are because of work relations, are difficulties in relationships, miscommunications, misunderstandings, and probably all the people that we've got online today. I suspect that's probably your experience as well. And I'm sure that Simon will echo that when he comes on to talk about the mediation process. So let's move on to the next slide. So one of the aspects of the ACAS Code of Practice is looking at informal resolution, and most grievances can and probably should be resolved at an informal stage. And I suppose, and you should, as an employee, should try and resolve grievances informally to start with. And I suppose how both parties or the parties approach a grievance process will very much dictate the outcome. It's important, and it's really important that I think, whilst, and again, experience sort of dictates this, when people raise a grievance, that that step, that person taking the step ups the ante, doesn't it? Ups the stakes. And so it's quite difficult to try not to, for the parties not to come to this in an antagonistic way, which is how we would recommend you do, to try and keep an open mind. But that can be difficult, I think, for the complainant. And if they're complaining about an individual, their back's already up. But if you can nip things in the bud, as said on the slide there, before they escalate, that has to be preferable, rather than making the making the process formal. And this nipping in the bud should be part and parcel of managing everyday work relationships, so that they don't become something that they don't need to. Why do you want to try and nip things in the bud at an informal stage? Well, it could be that you're misunderstanding, or there are misunderstandings in terms of what the employee has concerns about. Yeah, just going back to that slide then. So, you know, it may be that someone says, you know, I can't cope, I've got more work than everybody else, it's not fair, etc., etc. And it may well be that just unpicking that and offering that individual support and perhaps new training if they're relatively new will be a way of dealing with that concern, rather than going through a formal process. So try and think about it flexibly. Try and think about what individuals want out of it at the end of the day. What does resolution look like? And of course, we would always recommend that you keep a written note, just so that you can document the fact that this issue has arisen, you've dealt with it informally, and that there has been a resolution and the parties have walked away away from that content. I have to say, interestingly, I'm dealing with an issue at the moment where that very issue has arisen, where something was dealt with, we thought, informally, and has now made its way into a potential new claim. So we have got a note of that being dealt with informally, so it's going to significantly, what's going to make that individual's arguments around us not dealing with things properly much weaker. So I would always recommend that you keep a paper trail, and if possible, get the employee to sign up to that as well. So that's informal resolution. It's about being grown-ups, isn't it? It's about having some of those discussions and documenting them and looking at how you can resolve things. So if we go on to the next slide, so formal process. So what are the initial considerations that you would want to think about? So does this need to be, do we need to make any immediate, do we need to take any immediate steps in relation to this? What support arrangements might we need to put in place in relation to the employee who is making the complaint? and for the employee about whom the complaint may have been made. So do we need to change their working arrangements? Does anybody need to be suspended? And I would recommend that you think quite carefully about suspension. Suspension should always be a neutral, or is always considered a neutral act, but you do need to think about what the purpose of suspension is and whether or not it's needed in the circumstances. Consider whether the extent to which an investigation is required, and it's likely if you're in the formal part of this process that an investigation is likely to be required. Who is going to undertake that investigation? Think through who is going to be needed and at what stage of the process. So make sure that you've got enough people left who are not tainted or involved, should I say, in the investigation stage, or who's going to hear the grievance at the end of it. Think about timescales for response and keep people updated and adjust where necessary. So most feedback that you get from grievances is, I didn't know what was happening. I feel abandoned. It's going on and on. I'm feeling it's making me feel stressed. All of those things, if you can manage people's expectations, keep them in the loop in terms of timescales, they will feel much more involved and they will feel much more supported by the organisation. And that's really, really important. That a lot of feedback you get through grievances is how stressful it is. And they are stressful processes, just their very nature. But if you can try and mitigate that as far as possible, that is really, really, really helpful. Okay, let's move on to the next slide. Again, just looking at the formal process, the input is for the employee who's making the complaint to explain their grievance and what they would like to be resolved, what they would like to see at the end of it. You need to have a meeting with the employee, and the employee has the right to be accompanied to that meeting either by a trade union representative or a work colleague. The grievance will then be investigated, and the decision maker will decide on appropriate action and write to the employee to communicate the outcome and offer the right of appeal. So again, you need to have a right of appeal in the grievance procedure. One issue that often comes up is I don't want my union rep to accompany me, or I don't have a union rep, and I don't feel that I want I haven't got anybody within the organisation to accompany me. Well, strictly speaking, the rules say that it's only the right to be accompanied by those two categories of individuals. I normally keep a fairly open mind in terms of if they feel, and depending on the nature of the complaint, if they would feel better supported by a partner, a friend coming in and accompanying them, I'm usually fairly relaxed about that. Different employers take a different view on that and have a much firmer line on it. But I think you do need to think about it on a case-by-case basis, and does it in any way undermine your process by allowing another person to accompany them? I think you need to be quite clear about that, what their role is in that meeting. They are there as a companion. They're not there to make representations on behalf of the employee. I would, however, absolutely draw the line at legal representation because it's not necessary. It's an internal process, and you don't need to be lawyering up at that stage. Certainly, the employer wouldn't look to be legally represented in that situation. As I said, different people have a different view on that, but that's just sort of my take on it. If we move on to the next slide, please. Some of the tricky issues then is those situations, and I'm sure for those of you who deal with grievances and these sorts of issues, is those situations where someone makes a complaint or raises an issue Is that a grievance? Are you raising a grievance? What are you saying to me? How should I deal with it? And it's on the slide called tricky issues. It's tricky. Again, different employers will take a different view, and that's not right or wrong. It's just different. But I would always ask them and say, look, you know, this is really important. This is serious. I can see what you're saying here. Would you like me to treat this as a grievance? And this means that it will be dealt with in accordance with the procedure. Do you want it dealt with informally? What do you want me to do with it? It's not unusual for someone to say, I don't want to make this as a grievance, but I want you to know. I want you to know that I'm worried about this, or I've got concerns about that. And it is difficult to know when the line has been crossed in terms of what you then do with it. Again, you need to think about it on a case-by-case basis. If these are really serious allegations, then you do need to crack on and look into it. And you need to do that in order to protect the employer, the organisation's position, because it may well be that other people might be put at harm, or there may be allegations of fraud, or all of those sorts of things. So you just need to be sensible and look into that. What happens when an employee raises a grievance? Again, they say, I'm just telling you this, but I don't want you to do anything further with it. Again, as I said in the earlier bit, you do need to note that down, so that in circumstances where they come back at you 6 months later and go, oh, and I said this to you and you did nothing with it, and now I feel that you've breached my trust and confidence in the company, and now I want to resign. You need to have that bit of paper, don't you, where you say, well, we discussed this, we talked about resolution, and you said to me that you didn't want to take it any further, and I respected those wishes. Yes, most definitely keep a note of that. It's not unusual, is it, for a grievance that then leads to a disciplinary or leads to a counter grievance? So that situation where somebody says, I've been harassed by somebody, they've made inappropriate comments about me to third parties, or they've made inappropriate comments to me, and I feel that I'm being harassed in the workplace. If that finding, if a concern is raised to that extent, and there seems to be something in that, then you as the employer will need to flip into a disciplinary procedure and notify all the parties that is what is happening. As I said, it could lead to a counter grievance. So certainly I've seen it in the past where somebody says, oh, my line manager or my colleague who sits in a different team or in a different pod, she's a bully. She deliberately undermines me in front of our line manager, and she does this to make me look bad and her look better. And so you start the process, and then she says, well, actually, it's the other way around. She's actually the bully, and I've got examples that show that she has been bullying me. So you will have to take those seriously, and you will have to deal with all of those grievances together. And I would recommend that you do it in one process, so not to complicate things, and then you'll have to arrive at an outcome. And cross grievances, I would say, leading nicely into Simon's section, are perhaps where you've clearly got a breakdown in working relationships. A mediation may be a way of getting somebody to come into the organisation and look at whether or not there is an opportunity to resolve this in a different way, rather than I hate you and I dislike you even more. Let's move on to the next slide. So looking at effective grievance resolution. So we often get involved in advising employers on how to deal with grievances and how to manage them, because they potentially can open up an employer to liability. You need to be very careful about how you obtain legal advice, because and especially around draft decisions. So draft decisions around grievances are disclosable unless they are legally privileged, and they will only get legal privilege in circumstances where you've asked your solicitor to look at them for the purposes of obtaining legal advice, and that bit is really important. Just sending it to me or another solicitor in our team and saying, you know, FYI, that's not going to get, arguably that's not going to be privileged because you're not obtaining legal advice in relation to that document. So think about that, think about version controlling, because if you've got to a situation where you have a grievance, it's possible, not likely, but it's possible that this will end up in an employment tribunal. And we as lawyers, I mean, that's our training, we're always thinking about what's next and what the potential implications of that could be. In terms of grievance resolution, looking at the next bullet, is the grievance going to be upheld in full or in part? Or there might be a finding in part, there might be a finding on each part of the grievance. So in relation to the complaint that I've had an excessive workload, the finding is X. In relation to I've been ostracized by my colleagues, the finding is Y. So you would probably look to break it down like that. I think over the years there's quite a, I'd be interested to see what Simon says on this, but there is always a there seems to be a temptation or a tendency to just not uphold anything. And that will lead to employees feeling like they're being stitched up and they're not ever being listened to. Don't be frightened of upholding parts of the grievance. They may well have a, you know, it is possible that individuals have behaved badly, but it's about how you then move forward. So in terms of resolution, what are the lessons learned? What has come out of this grievance that perhaps you weren't aware of is going on elsewhere within the organisation? So what are the lessons learned? What staff training or guidance might be needed as a result of what has come out of the grievance? Do you need to think about one person apologising to the other? What about mediation? And Simon's going to come on and talk to you about mediation. Does disciplinary action need to be taken? So those are all of the things that are likely to come out of a grievance procedure. That's a bit of a canter through workplace resolution in terms of the grievance procedure. They're always they are difficult I think by their very nature. When somebody makes a complaint about the organisation, the management, colleagues, it's personal and it's difficult, and I think it's really important to remember that and to deal with it sensibly, empathetically, and transparently. But mediation is something that you may want to think about as part of the grievance process or as part of an informal resolution process. So I can see that Simon's got his camera on now, so I'm going to turn myself off so I stop talking and hand you over to Simon.
So Ellie, before I launch into this next slide, if you can just launch the poll, please. And I just want to know for the people on this call, do you have a experience of workplace mediation? So it's just yes or no. So I guess experience is being involved in it, or doing one, either as one of the parties or the person doing the mediation. So far away. So we've got the referendum split. So it's 52% say no. So it's nearly half. So that's interesting. So thank you for that. So close that. So what we'll do, we'll look at what a typical mediation session looks like shortly, but in this slide, we'll look at the key aspects of mediation. So the first one is being heard. One of the key aspects of the joint mediation session, the joint mediation session typically happens in the second part of the mediation day, usually in the afternoon, if it's been done in one day, is uninterrupted speaking. That's and so that each party gets to speak in an uninterrupted way to the other person. And the role of the mediator is to ensure that happens. And the other side of that is to ensure that the other person is listening to them, actively listening. So, and if you see that they're getting distracted or eye rolling, then you need to intervene. So it's really important that both sides are get to speak and are listened to. One of the most important roles of the mediator in the morning session, when you're working towards the afternoon session, is to ask the parties to focus on what they need and gently encouraging them to express that as a positive request. So rather than focusing on negative criticisms, so sharing hurt, it's about letting the other person know what the impact of what's happened on them. So movement and clarity, it's about being future looking. It's not about raking over. I do investigations and I also do mediation. Investigation is often sort of raking over what's happened, but the focus with mediation is, how is this going to look on Monday? How is this going to look? How are you going to work together from now on? And how would you like things to work in the future? So, and asking about clarity, what will that, the mediator will be asking, what will that look like? So you encourage them to avoid sort of vague aspirational statements about, Monday morning there's that meeting, how would you like to be spoken to by the other person in that meeting? And if possible, it's the parties reaching an agreement. It's one of the key aspects is it's self-driven. The parties themselves decide if an agreement is reached, and if so, what's in it. The vast majority of time, agreements are reached, but it's not essential. And sometimes agreements are reached the day or two after the mediation session. It's quite often it happens on the day. So next slide, please. So when can it be used? I'll talk quite a lot about this. Often it's best to use it earlier rather than later. It's before positions becoming too entrenched. We do a lot of grievance investigations, and they involve people making criticisms of each other. Often it's done in a strongly worded way, and that language can become stronger through the process. When I'm talking to someone about, this person's raised grievance, they said this about you, often they respond in quite a hostile, defensive way, and you pass that comment back to the other person, and it escalates, and you can move into a situation where you're finding yourself with a counter grievance. Al's already mentioned that. And so that's that way of that escalation can then be quite difficult to unpick once, if you then say, actually, I think this is right for mediation. It's often better before that escalation happens, before, mixing my metaphors, before people become too entrenched in their positions. So it's often better to try and identify it at an early stage. So the most common issue identified in mediations is a breakdown in communication. There's often issue with communication styles. Mediation is very good at allowing people to express, on the one hand, how their messages were being, how the other person's messages were being received, and the other person saying, well, this is what I was intending to say. The mediation I did recently, it was in last month, you could really see, when we got into the afternoon session, the scales falling from the eyes of the people involved, because they were explaining to each other what their own perspective was on how they've been communicating with each other. And once that happened, they moved very swiftly to an agreement, and it was really unlocking that, then being honest with each other about how they've been communicating with each other and the effect that was happening. And they just didn't appreciate how their own communication style was impacting and was landing with the other person. When the other person say, well, this is what I heard, this is how I received it, they go, oh, I wasn't meant to say that. And that really unlocked the whole thing. So it's not, useful for everything. It's not good for, it's not useful for like a bullying or harassment case. Let's say you've got a manager who's accused of sexually harassing a junior colleague. It wouldn't be appropriate to get those two together and say, let's see, can you find a way where you can work together? Or misconduct cases, if you've got someone who's accused of theft or fraud or being drunk at work, you're not going to be saying, okay, let's sit down and see how we can resolve this through mediation. So it's not suitable for all sorts of workplace issues, but particularly breakdown in communication. I think mediation is a very good way of unlocking a problem and moving on. Next slide, please. So I think it's really helpful to look at how we would run a mediation session. This is very tried and tested method. So it's the first process is the individual meetings. So you meet with both people individually for an hour at a time, and you start by telling them it's confidential, that no one else is involved, and the notes of the mediation get destroyed at the end of the day. It's voluntary, and it's really important that both parties are there on a sort of voluntary basis. They're not told they have to be there. And my role is just an impartial mediator. It's driven by the parties. I'm just there to add structure to the day. Then I get each person to tell me their story. And then I ask questions about the impact that that's had on them. And then crucially, you ask about what their needs and goals are. And then you ask them to prepare a statement, a written statement. That's at the end of that first hour session. And that statement is going to be something they're going to read out if the mediation goes on to the afternoon session. That statement they're going to read out to the other person, typically 5 minutes worth, a couple of sides of A4. And then you will do that with both people. And then you have another individual meeting in the morning. And that's where I'll ask them to read out their statements. And I will go through that statement and I will be asking them, how the other person is going to react to that and how that will assist reaching agreement. What I'm not doing, I'm not passing on messages. I'm not doing sort of Henry Kissinger shuttle diplomacy. I'm not going from person to person saying, well, they've just said this. What are you saying about that? And I'm also, I'm not making any suggestions. I'm not saying, well, do you think that would be better? I'm just questioning all the time. I'm not making any judgments. I'm not saying, oh, that seems a bit strong. I'm not making any evaluations. I'm just asking them, how do you think that that will be received by the other party, and what are you hoping to achieve, and what you've just said, will that help you to get there? So the analogy I was told is at the start of mediation, people arrive with various carrier bags of crumpled laundry, and the role of the mediator is to help them choose the main bits of laundry, fold that laundry into a neater suitcase, and it's that suitcase that they'll present in the afternoon session. So then you usually have lunch, and then in the afternoon session, you'll have that uninterrupted listening time that I mentioned earlier, where both sides just read out their statement. Usually I'll ask a couple of questions around it, but both sides get to read their own statement out. They're not responding to each other's statements at that point. And then they start to, then effectively the mediator takes a step back, and they then start to discuss whether they can find a way forward, having heard what the needs are, what the other one is looking for, and reflecting any hurt that they've suffered. And then you move on to problem solving and trying to reach an agreement. And effectively, the mediator is there just to, it sounds emotionally exhausting, mediator. It is tiring because you're absorbing quite a lot of upset and anger. But through the day, there's quite a transformation. The one I did recently in the morning, I was thinking, well, these guys are miles apart, and I was thinking, well, the first person wanted to tell me about 4 years of issues, and I was thinking, well, how are we going to compress this and get this ready for the afternoon session? But through questioning, you get them to the point where they are ready to talk in a positive way and things they're looking for, and it's very rewarding when you get to the afternoon session. Then you feel like you've really helped resolve an issue. It's interesting because I do investigations, and I was thinking, well, actually, if I was doing this as an investigation, having heard what they've said, I think they're probably looking at a 5-6 day investigation, interviewing all the various people they've mentioned, going through all these 4 years worth of hurt that she's just identified, and the other person identified a lot of issues themselves. So you probably like 5 or 6 days, including doing the interviews, writing up the report, gathering all the documents. And so that's 5 or 6 days work, and this is all resolved in a day. So that's also useful, and everyone's much more positive at the end. But yes, it is hard work. What happens when? Yes, it has to be voluntary. So both sides have to want to do mediation. You can't. And one of the things through the mediation day is you check. There's a pre-call as well you do before that, you use a couple of days before the mediation, and you emphasize the need that it has to be done on a voluntary basis. And if it's not done on a voluntary basis by both of them, then it doesn't go ahead. You can try and explain the benefits of mediation to them, but ultimately, if both of them don't want to be there, then, or one of them doesn't want to be there, then the mediation shouldn't go ahead. So I mentioned the joint agreement. So on the agreement, there's about a 90% success rate. So sometimes the parties might agree to share the agreement. I mentioned earlier about deleting and destroying all the notes, and that's really important that the notes get destroyed. But sometimes the parties might agree that the agreement would be something that they would be prepared to share, but there's no requirement on them to share that. So the mediator is not there to make. So I've seen quite a lot of questions coming in, but I'll just get to the end of this slide. So yes, we're not there to take sides or make judgments or make any suggestions, and I think that's also a challenge. If I can see something where I'm hearing both people saying this is an issue, the temptation is to say, well, what about trying this? But what you have to do is you have to ask questions and get them to arrive at their own conclusions about how they want to do it. So there's a temptation to make suggestions, but you've got to really avoid making any suggestions. It's just about questioning them, and it's self-driven. It's for them to arrive at their own conclusions and agreement if that happens. So the next slide is going to be back to Al, but shall I just tackle? I just saw quite a few questions coming in.
Yeah, there's quite a few. There are quite a few questions. There seems to be some around the extent to which the information that is generated as part of the mediation is disclosable. So the mediation agreement, and I suppose any notes. There's also a question here around confidentiality and how that sits within the whistleblowing sort of framework. But do you want to sort of have a look at some of those questions?
Yeah. So I think if anyone admits to an offence, for example, then you have to abandon the mediation. You have to stop the mediation. So, but apart from that, or if someone really starts to sort of bully during a mediation, then you'd have to stop the mediation. But apart from that, the mediation, the emphasis is on confidentiality, and everything gets destroyed at the end of it.
Presumably the mediation agreement would remain a live document.
Yes, well, yes.
And the extent to which the relationship broke down again, and there is an issue around that, to the extent that processes need to start up again, you would rely on that, wouldn't you?
Yes, yeah. Often, so sometimes it can just be a verbal agreement, and sometimes the agreement they will prepare themselves. But quite often on the day, you get some momentum during the afternoon. I mentioned the sort of scales falling from their eyes, and so they were sort of wanting to get to an agreement, and so I then just typed an agreement up on the day as we got there, and they effectively dictated the agreement to me. And part of your role is to sort of challenge them and say, well, let's make it a bit more specific, or can can it be made more specific? But really, it's their agreement, but it's entirely up to them what they do with it. And the one I did recently, they didn't really want to share it with anyone because both of them had a fairly dim view of a couple of managers, and they didn't really want to share it with the managers involved. So yes, they wanted to keep it entirely confidential between them, but that was kind of enough for them. And the other thing you do as a mediator, I will be shortly checking in on them. You sort of check in over a period of up to a year, on a sort of monthly basis, just to say, how's it going? Is there anything, is there anything I can help with? But yes, so you don't just abandon them. You do check in on them. Should you be properly trained for mediation? I think I would say it's a good idea to be properly trained. I've investigated quite a lot of situations where following mediations that have been done badly, where effectively a manager's got two people together and effectively decide to sort of knock their heads together. They've got together at the early stage, the sort of angry stage, the angry laundry stage, where they just said, here, you two go together and I'll knock your heads together. And it really went badly and made things a lot worse. And you end up with a very toxic grievance that came out of that. So I would suggest it's sensible to try and I would say get trained before you did try it, because there's things that you learn on the course that are not instinctive. The instinct can be to be a problem solver and to just knock heads together and say, come on, let's just fix this.
And that comes, I think that comes
yes.
to the parties taking ownership for their own
yes.
resolution, doesn't it? Just one other point on trained mediators. One of the questions is around internally trained mediators compared to external mediators like yourself. My answer to that would be it depends. It depends on how big your organization is, the extent to which somebody internally can be perceived as being neutral or perceived as being not neutral. And I think that's one of the benefits of bringing somebody like Simon in from outside of your organization. Would you agree with that, Simon?
Yeah. I think particularly the issue with sometimes internally a manager who's known to both of them, I think sometimes they're going to be less likely to sort of open up to them if they think, well, I'm going to be seeing this person tomorrow. And I think that can also be a temptation of a manager just trying to fix something quite quickly and jump too quickly to the process, to the end of the process, which is definitely to be avoided. Yes, but there's nothing to say you can't do it internally, but I would recommend that if a manager is going to do it, that they are trained to do it. And
that both of the employees involved in it are happy and agree to that individual undertaking. Because as soon as they say no because they are impartial because of X, Y, and Z, that's a bit of a red flag. There's a few more questions on here. There's one that says, do you offer any training on dealing with grievance for managers? Absolutely, we do. So we can come back to you on that. There's some fairly specific questions. I'm sort of a bit mindful about the time. It's 10:53. Simon, do you want to answer any of the other questions that are on here? There's somebody who's raised the question here, had good experience with ACAS. What should HR practitioners look out for? Is it appropriate to raise concerns with the mediator beforehand, or would that bias the procedure? So presumably that is around, you should just know that this individual is whatever and the other individual is whatever. What would your view, Simon, be about that? Would you want to come to a mediation completely neutral without any information about the background?
Yes. I mean, normally we get as we want to know as little as possible really beforehand. We will speak to the parties beforehand, usually a couple of days before, just to explain about the mediation session. But really, we don't want to come to it with too much information. It's just really so we are there because we're not there to take sides, and so we don't really want a lot of pre-reading, because the idea is we're trying to help them find a way through, rather than doing a deep dive into the detail, because there just isn't time to do a deep dive into the detail.
Yeah, I think that's right. There's one interesting question that's come up here about how you would undertake a mediation where you've got somebody who is neurodiverse. I suppose from an employment lawyer's perspective, we would be looking to try and think about what adjustments that individual may need in order to be able to participate in a process such as this. So probably understanding what their neurodiversity is and what adjustments they require. Simon, I don't know if you've got any thoughts about that.
Yes, I think you tend to avoid people being accompanied at these things because it's really, you want to hear their voice. But I think if they're going to find it challenging or that there are issues, then you might think about them being accompanied. But I think your mediator would have to make sure that what they are hearing is those persons' views, not the person accompanying them's views. Because it's not the same as a grievance. It's quite different. It's there to try and see if there's a way of agreeing a positive way forward.
Yeah, I mean, a grievance procedure is understanding what's happened and then coming and then sort of not enforcing, but coming up with an outcome that the individuals, either the complainant or the or the complainee is going to be unhappy with. One question that's just come in, which is again another interesting one, is what happens when mediation breaks down? Well, my experience of being a lawyer involved in mediation is that you know fairly quickly whether mediation's going to work or is not, and really when it breaks down, you down tools and everyone walks away. And again, I suppose my experience is that doesn't necessarily mean that is the end of it, and people have time to reflect and may come back to it.
Yes, and as long as, because one of the things you emphasize about is the confidentiality of it, that this mustn't go, what's discussed here mustn't go beyond the four walls of the mediation. And I guess it depends. Interesting to see at what point it breaks down, because the session is the individual meetings and then the joint meeting. So I mean, it's the individual meetings, then all that's happened is those people have explained to the mediator what their issues are, and so there's nothing really to disclose. Obviously the mediator is not going to the mediator shouldn't be disclosing that to anyone, so it's only that person explains to the mediator what their issues are and possibly preparing a statement. I guess if it falls apart once you've had during the afternoon session, then you have heard what the other party is saying then.
Yeah, I've got, there's one person on the question, the Q&A box, who's asked quite a few questions. I'm happy to deal with those outside of this. We're running out of time, actually. But I will, let me just type an answer in the box. Hi, happy to deal with your questions. Can't type now, questions offline. But you do raise some very legitimate and good questions, so happy to deal with those. I hope that's okay. I think that's probably got us to the end of our time, hasn't it?
Yeah, there was the key takeaways.
Sorry, Simon.
Yeah, there's the key takeaways slide that we were gonna.
Yeah.
Yeah.
So I suppose the key takeaways are recognising the value of solutions-focused approach, resolving workplace conflict. And I think given the number of questions that we've had as part of this process and as sort of part of this presentation, there's lots of interest and lots of curiosity around doing things differently and looking at how to resolve workplace issues. So so thinking about mediation and whether that could be an alternative to a formal process like the grievance procedure feels like it might be something that you are all interested in. It's really important to get the parties involved, feeling acknowledged and listened to. And I think Simon's illustrated that really, really well. This doesn't always require upholding any grievance and having a finding made in favour of one person and against another person. And then just think about how things can be done differently and improved going forward. I don't know if you want to add anything to that, Simon.
No, I think that's you've captured all the stuff there. So just going to move on to the last slide, which is just to let you know about the HR and employment law courses we do. These are online short courses with videos in and content, and they deal with the key areas of dealing with that come up with in dealing with employees. So I've done the carried out an investigation one, so it tends to be a lawyer and someone from the Narrowkey HR team, and so we give different perspectives, but there's sort of quizzes and tests through them. And so we've just put a poll there to say if anyone would be interested in knowing a bit more about it, please let them know.
So we've got lots of nice thank yous. So thanks, guys. I'm not sure if everyone's done the poll, but it's been really good. I've definitely really enjoyed doing this with you, Simon. It's always nice to get a different outlook on these sorts of things rather than me just looking at it very in a black and white legal perspective. So it's been really great. So thanks, everybody. I hope you really enjoyed it, and hopefully you'll log on for the second part in this series.